Mark mentioned, my name is Elizabeth Kronk-Warner. My pronouns are she, her. It's really a pleasure to be with you here today. I want to thank Mark for inviting me, and not only inviting me, but being such a hospitable host. He did everything to make sure that I was prepared and that I was excited for this conference. So very, very happy to be here, and a big thank you to Mark. I am incredibly impressed by the caliber of today's presenters and tomorrow's presenters. It's going to be a phenomenal conference. So it's great to be able to kick it off with an important and timely conversation. And so today we're really beginning with an important topic, and that's ethics and civility. When reading the newspaper, one may question the resilience of such principles into today's day and age, especially in the political sphere. It raises the question of what is a practitioner and a lawyer's role when it comes to ethics and civility. A lawyer's conduct should be characterized at all times by personal courtesy and professional integrity in the fullest sense of those terms. In fulfilling a duty to represent a client vigorously as integrity, lawyers, we must be mindful of our obligations to the administration of justice, which is a truth-seeking process designed to resolve human and societal problems in a rational, peaceful, and efficient manner. We must remain committed to the rule of law as the foundation for a just and peaceful society. Conduct that may be characterized as uncivil, abrasive, abusive, hostile, or obstructive impedes the fundamental goal of resolving disputes rationally, peacefully, and efficiently. Such conduct tends to delay and often deny justice. Lawyers should exhibit courtesy, candor, and cooperation in dealing with the public and in participating in the legal system. Now, these words are not my own. They are the preamble to Chapter 14, Article 3, Rule 14-301, Standards of Professionalism and Civility from the Utah Supreme Court Rule of Professionalism and Practice. I think we would all agree that they are words to which we should aspire, but we can question whether or not we do. So I'm very pleased to be sitting with my esteemed colleagues here and jurists to really discuss what ethics and civility mean under these rules. So today's distinguished panel will help us to understand what the contours of ethics and civility are in the modern era. So with that, I'm going to introduce our two speakers for today, and then I'll turn it over to them to have this important conversation. So first is Judge Dianna Gibson, who was appointed to the 3rd District Court in January 2019. She presently serves in West Jordan. Judge Gibson received her law degree from the S.J. Quinney College of Law, which is wonderful, in 1996, where she was a national moot court finalist. After law school, she practiced law, including antitrust law, with the firm of Parsons, Bewley, and Latimer. In 2008, she became Associate General Counsel for ATK, a global aerospace company. In 2013, she was promoted to Vice President and Associate General Counsel at ATK. In 2015, she was appointed Vice President and Deputy General Counsel for Vista Outdoor Incorporated in Salt Lake City. And of course, in the beginning of 2019, she was appointed to the bench by Governor Gary Herbert. Next, we have Judge Laura Scott, who was appointed to the 3rd District Court in October 2014, also by Governor Herbert. She took the bench in January 2015 and served Salt Lake, Summit counties. Judge Scott received a bachelor's degree cum laude from the University of Utah in 1990 and graduating Phi Beta Kappa. She graduated cum laude with a Juris degree from the Sanja Day Connor College of Law at Arizona State University in 1993. After graduation, she served as Assistant General Counsel for the University of Utah from 1993 to 1997. She then joined the firm of Parsons as well, where she maintained a commercial and real estate litigation practice, including trial and appellate work. She served on the firm's board of directors from 2010 until her appointment to the bench. Judge Scott is an American Bar Federation Fellow, a former Vice Chair of the Ethics and Discipline Committee of the Utah Supreme Court, and a past President of the Salt Lake County Bar Association. She received the Utah State Bar Professionalism Award in 2014, and prior to her appointment, she served on the boards of Salt Lake Valley Habitat for Humanity and the University of Utah Crimson Club. So with that, I'll turn it over to our two incredibly distinguished jurists, and we'll hear about ethics and civility in the modern age.
Well, first of all, it's a pleasure to be here today, and I come at this topic from the perspective of someone who's only been on the bench 5 years, and so I haven't been on the bench long enough, to forget how hard it is to be a lawyer and how hard it is to be a litigator. I've had back-to-back jury trials, and they're exhausting as a judge, but when I left at 5:30 or 6 that evening, I realized I could go home, I could enjoy the evening and just show up the next morning. The lawyers who were in the courtroom were going to be spending another 5 or 6 hours preparing for the next day. So, please know that when we talk about these issues, from my perspective, it's really about what didn't I know when I was a lawyer that now I see it on the other side as a judge. So things that seem normal, seem typical to do, why they're frustrating for judges, why we view them as uncivil or unprofessional, or even the kind of conduct that lacks integrity and that calls into question your honesty and your role as a trusted advisor to the court when we're trying to make decisions. So when I first became a judge, I felt like I had to apologize to a lot of my colleagues on the bench for things that I did when I was a lawyer. And so again, I just want to come at it from the perspective of these are helpful tips from what we see, not necessarily things that you would necessarily know or would be intuitive when you're a litigator.
And I echo everything that Laura has just said. I've only been on the bench a year, and I was a litigator for about 10 years with Parsons, Bailey, and Latimer, and then I went in-house for 10 years. So I also look at this from the standpoint of managing outside counsel who, in effect, the way I looked at it, I never hired outside counsel to be my hired gun. I always viewed them to be an extension of my in-house team. They were a reflection not only on me, but on my company and also on the brands that we represented. So from my point of view, our presentation is meant not only to be a tactical discussion about what is in and outside the bounds of ethics and civility, but also give you some thoughts about the strategy behind civility and what may be important to your clients and also what may be important to you from a career perspective.
One of the reasons before some of you came in, I asked the audience to introduce themselves is because it's helpful to know who's a new lawyer, who's been around for a while, because I think there are different tips. And so let me just start by maybe talking to the new lawyers or the law students who will soon be lawyers. As you enter this profession, it is so much easier if you start with the perspective of I am going to be professional, I am going to be civil, and I'm not going to allow a client or opposing counsel to dictate how I approach a case or behave in court. And that's hard to do because when you're starting out, you're trying to get clients, it can be very difficult. Clients, I think, often have an unrealistic expectation of what lawyers do based on what they see on television. So just a couple tips as you're starting out that I've seen work. One is to just explain, and this kind of goes to number 2, lawyers shall advise their clients that civility, courtesy, and fair dealings are expected. They are tools for effective advocacy and not signs of weakness. Clients have no right to demand that lawyers abuse anyone or engage in any offensive or improper conduct. I think it's helpful in your engagement letters with clients to articulate that you abide by these rules and that things like granting extensions of time are going to be your decision to make, that the client's not going to have a veto power over you, that while they get to make the ultimate strategy decisions, that you are going to operate within those rules. You can share decorum orders with your clients. When I'm getting ready for a jury trial, I'll issue a standing decorum order that sort of explains how the trial is going to run, but also what I expect in terms of client behavior, attorney behavior, et cetera. Those should be shared with your client. I think it's also helpful to explain that judges and juries really don't like sarcasm, insults, hostility, et cetera. You may think you're aggressively cross-examining a witness. I can guarantee you I will talk to the jury afterward. They hate it. They absolutely hate it. They can see when a witness isn't answering the question. They can see when a witness is being evasive, and they don't like it when attorneys get down in the mud. So those are just a couple things when you're starting out. Oh, and the final thing I would say about that is I have always regretted representing a client that at the beginning of the representation I thought would be difficult. The clients who expect you to treat others inappropriately or with disrespect are the same clients who are not going to pay your bills. They're going to file a bar complaint against you or some other issue. I just never, any time I've said, I'm not sure about this client, I've always regretted it.
So tying into that, it makes me think about a speech that I read. You know, it's really interesting when Mark, do you want me to come on closer? Oh, so when Mark originally asked me to participate on this panel, you know, I was thinking, what could I possibly say about civility? Be a good person. Don't be obstructive. Don't be rude. I mean, all those things seem to be very commonsensical and very commonplace. And then you start reading about different philosophies about ethics and civility, and this topic about the erosion of civility has been going on for a very long time. And the quote that I want to read to you is from Justice Sandra Day O'Connor from 1993. And it's from her speech to the ABA, and part of that speech was discussing the erosion of civility. And so these are her words. She states, "I believe that the justice system cannot function effectively when the professionals charged with administering it cannot even be polite to one another. Stress and frustration drive down productivity and make the process more time-consuming and expensive. Many of the best people get driven away from the field. The profession and the system itself loses steam in the public's eyes. In my view, incivility disserves the client because it wastes time and energy, time that is billed to the client at hundreds of dollars an hour, and energy that is better spent working on the case rather than working over the opponent." I actually think those words from 1993 are very apt today, because I do think that part of what Judge Scott is saying is that you need to manage your client's expectations, and part of that is you have a duty to be a zealous advocate, but you also have a duty to be efficient, effective, and productive for your client. And some of the recommendations that may come from clients to be a bulldog, to be difficult, to not grant extensions, at the end of the day, I agree, it disserves them. And it does, and well, I'm going to go back and say, you know, when I was practicing as counsel, the last thing that I wanted to do was answer a phone call or respond to an email from opposing counsel who was difficult. And because part of that, it makes your day difficult, it makes your job hard, a job that is already hard. And so I do think that some of these efforts at being obstructionists and difficult as opposing counsel does disserve your client at the end of the day by increasing costs.
So let me talk about, most people will say, okay, I get it. I shouldn't call the other side a jerk. I shouldn't say they're lying. I shouldn't use disrespectful words like misleading and meritless and all of those words that we hear about. But I think as a judge, and these are some of the things I needed to apologize to my colleagues for, there are other ways that I think you can be unprofessional throughout the litigation process that may not be so obvious. And so you start with the beginning of litigation and the notion of I'm representing a sophisticated, well-funded client. So I'm going to just beat the other side into submission. I'm going to file a motion to dismiss, even though I know there is no way it is going to be successful, because I understand what the standard is, and the complaint is, it satisfies Rule 8, but I'm going to file it anyway. Judges see that. They see attorneys show up in a court. They see maybe a pro se litigant on one side, or they see an individual versus a large corporation. They understand what's going on. In discovery, I know attorneys want judges to call it out more. I've been trying to do that because I remember how frustrating it was when Judges could obviously see something was going on and wouldn't. And so I'm going to just share with you a couple things that I've written in relation to cases that kind of tie into this. And this goes to this issue of discovery and how you should not, let's see what standard it is. It's number 17, lawyers should not use or oppose discovery for the purpose of harassment or to burden an opponent with increased litigation expense, et cetera. So, and this kind of goes to both lawyers who've been practicing a long time and new lawyers. I mean, I remember when I would draft my responses, you'd have this wholesale list of objections that you would just cut and paste into your response. And this notion that what you're going to really try and do is parse out requests for admission or an interrogatory to answer it as narrowly as possible. So I had a case where I got a statement of discovery issues, and it related to, and this is the request. It was admission number 1, which asked the defendant to admit that he communicated with Jane Doe or another individual associated with XYZ Corporation regarding ABC Corporation, its employees, and/or its shareholders. So they objected to the interrogatory as vague and ambiguous because they didn't understand what associated meant. And so you end up engaging in litigation. You take the judge's time to argue over that. And my ruling in that, I awarded sanctions, but it also related to, of course you know what associated means. And even if you're not entirely sure, you get the gist of it from the context of the request for admission and do your best to answer it. And maybe there is going to be some dispute as to whether you covered everyone, but this notion of that kind of a question is too vague and ambiguous to even attempt to formulate an answer, I thought was just ridiculous and warranted sanctions. I had another case that involved depositions and a fight over what was appropriate in a deposition. And so these were some of the objections that I found sanctionable. And they were repeated throughout the deposition probably 25, 30 times. The attorney was obstructing the deposition and he was trying to coach his witness. So things like object to form, he just said he didn't know, go ahead and answer if you can. Did you understand what he asked? You're acting like you didn't. If you don't, tell him. You haven't established foundation on the question, so go ahead and answer if you can. It assumes facts, not in evidence, that he spoke to Jeff Brown, but you can make that clarify on the record if you'd like. The only reason is there is a driver of the truck and an operator of the forklift. I just don't want you to get those terms confused. He's going to use this Google map, and I think you'll find it fair. Just make sure that it properly reflects the circumstances on the day of the accident, but I don't think you can tell us when this was taken, right? So this is an attorney making objections, so his client is being coached throughout the deposition, and that was also sanctionable. So, you know, attorneys have done it for a long time, but that doesn't mean it's appropriate to continue doing it.
So I've had a couple of experiences on the bench with attorneys who have just been difficult for the other side. And I just want you all to know that, you know, I practiced, I was a litigator. I understand the tricks that lawyers do, and we can read it in the motions. When we get the pleadings, we see that someone is being difficult and objecting for no reason. And I'll give you one example. So I had a case where the parties had been negotiating a settlement, and they effectively reached a settlement agreement on a piece of property. They'd reached an agreement, but then in enforcing that agreement, they had a dispute about how they interpreted one of the clauses. They tried to mediate it, they couldn't get the result. So the plaintiff in that case files the lawsuit. They attempt to serve the lawsuit, and the defendants in the case are evading service. Defendant's counsel shows up in court and files a motion to quash and argues that the court should quash service, it wasn't effective, and that you know, his client just wants to be served under the rules. So my response was, well, you understand that under Rule 4, you can accept service. This is not the case where you have no notice. This has been thoroughly discussed. You reached a settlement. Now you're having a dispute on one issue. And defense counsel stated to me, well, I don't have my client's approval to accept service. And so my response to him was this, and his client was not in the room, which is also probably another topic that we can have a discussion about. So it was just the attorneys in the room. So my response was effectively this. We have two options here. One, I'll invite plaintiff to file a motion to serve you alternatively, and I will grant or I'll consider any reasonable costs and attorney's fees that may come from that. Or you can just accept service under Rule 4. And so ultimately, he accepted service. But those are some of the gamesmanships that people play. Please know that it does not get lost on us. To the extent that we can take action, we absolutely will. I always feel a little hesitant about, sua sponte on my own taking action. It is also helpful if when this stuff happens in discovery or in other situations that the lawyers also bring it to our attention so that we can address it as well. So that's one issue. The other thing that Judge Scott raised is, and as a practitioner, I did this as well, in your briefing, you write things like arguments are meritless or, and the argument made is illogical or is unreasonable. And I wanted to bring your attention to a case that I actually thought was really interesting on this. It's from the Supreme Court of Delaware. It's in the matter of the member of the bar, the Supreme Court, Richard L. Abbott. It's 925 A. 2nd, 482. It's from 2007. So in this case, the Supreme Court reviewed statements that had been made in this lawyer's opening and reply briefs. And the court determined that those statements were undignified, discourteous, and degraded both opposing counsel and the tribunal. And I just want to read to you some of the words that were used. Not that, I've never seen a brief where all of these references were made in the same brief, which is probably why there was a public reprimand in this case, but some of these may ring a bell for you. And the Supreme Court of Delaware determined that these were inflammatory characterizations. The use of the word fictionalized, miraculous, imaginative and creative writing skills, imaginary make-believe, laughable, illogical, irrational, meritless, whimsical, pure sophistry, ridiculous. The briefs also made a suggestion that perhaps the tribunal would reach a decision on something other than the merits of the case. And so for all of those reasons, the court found, and this rationale is pretty apt, I think. The reasoning is in this case, the court found that the use of that language did nothing to assist the court in deciding the merits of a motion. It wastes judicial resources by requiring the court to wade through the superfluous verbiage to decipher the substance of the motion. It does not serve the client's interests well and generally debases the judicial system and the profession. So while I would tell you that I've not seen briefs that contain that number of references that calls into question opposing counsel's character or their ability to serve their client, but at the same time, it does give you an idea of, even use of some of these phrases is inappropriate. From my point of view, I really want to just focus on what the merits are. When you use colorful adjectives and adverbs, I ignore it. And if your use of those colorful adjectives and adverbs don't accurately describe what I'm reading in the brief or what I will ultimately read, it does lead me to question credibility. So just please consider that.
I think to follow up on that point, one of the reasons as a judge, and I did not appreciate this as a lawyer because I use those words. They seem kind of harmless, meritless, unreasonable, creative arguments. I mean, they just seem like, okay, we're describing it. But as a judge, when you're reading so many of these briefs in a day, it feels like you're being yelled at. It's really strange when you're just reading it and you're not interested, you don't have a personal interest in the case, you're not representing the client, and you read briefs filled with these kinds of adjectives or insults or sarcasm. You do kind of just feel like you're being yelled at. So I think that's one thing. The other thing, so what do? I mean, how do you say, well, they misrepresented deposition testimony? I think it's just showing the contrast. Plaintiff said this in the brief, here's the deposition testimony verbatim. And we can read and we can see the contrast, and it allows us to feel your outrage without you having to tell us to feel outrage. One of the things I wanted to talk about is oral presentations, whether that's in oral argument or in a trial. I think there are some ways to kind of tell maybe if you're crossing the line. And so I'm just going to give you some hints about ways that if you think, again, I don't think most people go into this intentionally trying to be disrespectful or to be unnecessarily adversarial. But I had a case in front of Judge Davis. He's a 4th District Court judge. He's a great judge. And I had a very contentious piece of litigation, and we were dealing with sanctions, and they were potentially terminating sanctions against the plaintiff. I represented the defendant. And the plaintiff's attorney got up, and he was outraged because we were bringing this motion. I got up and explained why I was bringing this motion. And I guess it didn't feel like it was getting heated from my perspective. I thought I was coolly, rationally explaining my position, but Judge Davis said, I want you both to know how much respect I have for you. And I didn't think anything of it, and we kept arguing back and forth, and he said, Counsel, I want you to know how much respect I have for you. And it suddenly dawned on me what he was saying was, knock it off. If you keep doing this, that respect that I have for you, I'm going to lose it. And so it was a very subtle, I thought, very classy way of, telling us, knock it off, you're misbehaving, you're making this more difficult than it needs to be, and your credibility and the respect I have for you is on the line. I've been told in oral argument, I've had my people rolled eyes. I had one counsel tell me, quit interrupting me. Which I thought was really interesting because my job as a judge is to ask questions to make sure I understand your legal position. But nevertheless, he didn't seem to think there was anything wrong with that. He had a presentation. He was going to make it regardless of what I needed help with. But, if you suddenly see the clerks perk up, chances are it's not because your argument is brilliant and they're suddenly interested in this antitrust case. It's because they're wanting to see what I'm going to do. And so that's a clue that maybe it's gone too far. If in a trial, for example, before opposing counsel can even get out objection arg, and I've sustained the objection, it probably means maybe you're going too far, that I'm tired of the way in which you're engaging with a witness. I think if you can see the judge visibly trying to maintain that poker face that we try really hard to have, or you're sitting back, maybe that's a clue that you need to just tone it down a little bit, and again, understand that sometimes we feel like you're yelling at us when that's your behavior in either in a brief or in an argument.
And I will say that, as an advocate, I feel like I have sometimes in my head, I come close to crossing that line, or I want to cross that line because you get so emotional and you get so passionate about the argument. And you seem to forget where you are when you're making the argument because you are right and this is the winning argument. You should also know that as a judge, I have often struggled to keep my own emotion back when I see behavior that I think is uncivil to either a witness or to opposing counsel. And so I do recognize how challenging it can be to keep that poker face and remain emotionless. But it is it is absolutely critical that you attempt to do that. And the reason is that your credibility is on the line many times. One example that I'll give to you, I was in the middle of a bench trial, and counsel was having difficulty laying foundation for a document. He would attempt to lay foundation, it would draw an objection, I would sustain the objection, and he got to the point where he was so frustrated that he stomped his foot and rolled his eyes and told me that I was being unreasonable and that we would be here until next week because I was not allowing him to present his document the way he wanted to present it. And I will tell you that I do my best to try not to allow that type of behavior to impact my decision making. I will do everything I can to look beyond it, to address the substantive issues in the case. But when counsel acts like that, they do not make it easy, because it makes me question the credibility of not just that attorney, but the arguments they make, which does then impact his client. So also keep that in mind. We are always going to be told things that we don't want to hear. When I sustain an objection, when I rule against you on a motion, you need to take that, keep your poker face, and maybe go to your car and yell. Just do not do it in the courtroom. Yes?
What if he had asked you, how should I lay the foundation?
Well, and I will tell you, and I'll just give you an example, it's difficult for all of us to keep our own decorum. And this bench trial happened, I think I'd been on the bench for 3 months. It's also a little bit of a shift, I will let you know, to go from being an advocate to becoming a judge. There's a different way of interacting with, the parties in the room, and it's very difficult. So what I ended up doing, and I will tell you it's probably not one of my proudest moments, but he had done this on probably five different documents. Attempted to get it in but couldn't. And so after he did it the last time, after he stomped his feet, after I said, well, obviously you are upset with the court, and he said, yes, you're right. I find this to be one of the most difficult trials I have ever done. And I said, well, it's not my fault that you don't understand how to lay the foundation. And I'm not going to just sidestep and overlook rules of evidence because you want to talk about this document, but you're not going to lay proper foundation. So again, probably me going a little bit too far on the record. And then he said, well, Your Honor, I bet you could do it better than I could. So I turned to the client, to the witness.
This was a bench trial.
And it's a bench trial, and I laid foundation. So again, I will tell you that we all struggle with not walking over the line. It's very difficult even for us. And so, I laid the foundation and I gave it back to him. But again, not one of my proudest moments, a learning baby judge moment probably. I will not do that again, but it's difficult for all of us. And I'm not here talking about tips and strategy without revealing to you that I also struggle with this on the bench.
Does anyone have any specific questions? I mean, we've kind of focused on what we thought might be helpful, but yes.
I wasn't expecting to actually make a comment, because I'm an economist, but it strikes me that, part of our challenge, it seems to be broadly, and this is very helpful and interesting discourse, is what happens when civility doesn't work, or even more, when it seems as though uncivil behavior seems to be the rule of the day. I mean, we've now seen in the public discourse such a deterioration in the Kavanaugh hearings. I just flabbergasted from the standpoint of seeing this type of behavior from somebody who's going to be elevated to the Supreme Court. And it's not unusual in the Senate panel and so on and so forth. It seems as though this type of, it's not just grandstanding, it's a matter of, and it's starting at the top, really, that this kind of behavior seems to work and profoundly work better than it does to behave properly. It's almost quaint to be civil now and maybe wear a powdered, it's almost like wearing a powdered wig to do this in the courtroom when so much seems to be going on and playing off the public in a way that's impeding civil behavior. I was just wondering what your comment is.
Well, and I agree. I think it is challenging, and I'll talk about it from my perspective. I mean, one, I can't make a decision on the merits of a case based on which attorney is the bigger jerk, right? I mean, at the end of the day, if you're a jerk but you have the winning argument, it's really hard, unless we're in the world of terminating sanctions, to say, you know, I'm going to ignore precedent, I'm going to rule against you because you behaved inappropriately. But what I would say is, one, judges talk. And so we don't get together at lunch and talk about the really nice attorney or the really great brief. We talk about the attorneys who we think are unethical, unprofessional, who cause more problems. Maybe that doesn't matter for that particular case, but if you think about all the times as an attorney, that judges have to rely on your word, where we have discretion, things like good cause for extensions, discovery sanctions, all of those areas where we are really looking at, okay, do I trust this lawyer? Am I going to grant this extension because I believe the lawyer when she says, you know, this is the reason why we didn't produce the document, or this is the reason why we missed the deadline? I am much more likely to view that request favorably if the lawyer has been behaving appropriately in other cases. The other thing I would say is, I know my colleagues on the 3rd District bench, and I think we're all committed to calling out the behavior when we see it. I've dropped footnotes in decisions where I felt the briefing was inappropriate. I'm willing to award sanctions if you're obstructing the discovery process. I know my colleagues are as well. What I would ask is just make it easier for us by not getting down in the mud. I mean, you know, we have 2 lawyers show up and they're both just covered with mud. It is hard from our perspective to figure out who's responsible for it. But if you maintain that, I think you can assure your clients that really at the end of the day, it is beneficial to them, even if it doesn't seem like it because they lost the motion where the other side was inappropriate.
I agree with everything Judge Scott said. I also agree with everything that you stated about just the general state of civility today, you know, with public discourse, and then also, you know, how we interact as legal professionals. A couple things that I would say, you know, from where I sit on the bench, I don't have the ability to parent, you know, everyone who appears before me. I can't put people in timeout all the time. You know, I can't make a difference in that way. But what I would ask everyone to consider is this, from a more strategic perspective on civility. You know, I do think civility matters in 2 different ways. One, as in-house counsel, I hired, you know, outside counsel all the time. And as I told you before, I looked at them as extensions of me, extensions of my in-house team, reflections on the company. And competition for legal services is really hard these days, right? You've got the traditional law firms that continue to plug away, but now you have all sorts of very creative and innovative ways of providing legal services that everyone is competing with. So when I would go look for outside counsel, just price of entry is that you're a great, solid attorney or you come from a great firm. Everybody has that on their resume. What we are looking for are all those other intangibles that matter to us. You know, from my company, diversity didn't matter, comp structure didn't matter, because I wanted to make sure that everyone who was working on my case made it a priority, just like the managing partner. Values, you know, my last job I represented, we had a gun company, so we needed to make sure that the company also reflected the values of the company that I worked for. But most important, I would tell you that it was also an extension of me. I'm not going to hire somebody who doesn't practice the way I practice. And if you're known for being uncivil and a bulldog, that's not what I wanted out there reflecting me or reflecting my company. So it does matter for purposes of clientele. In addition, I would also tell you to think about it this way. Your reputation does precede you, as Judge Scott stated. This client, this job you're in, may not be the only job you have forever. And when you are looking for other jobs, it does matter how you've treated your colleagues, both superior and subordinate. It matters how you treated your legal secretary. It matters how you dealt with outside counsel and the court, my staff, witnesses. All of that matters. And sometimes you may luck out and maybe bad behavior falls through the cracks and someone gets that job and everyone goes, how did that person get that job? Sometimes that happens, but I bet you there's a lot more times where people don't get the jobs that they want because of these things that they were completely unaware of. So I would ask you to consider that as well.
Unfortunately, I think we're about out of time. Please join me in thanking our very distinguished panelists for what was an incredibly interesting and thought-provoking presentation. So thank you so much.
And enjoy your conference.
Yes.